or this third episode in our series involving our presentations from our members and friends in the Eurasia region. On Monday, we had presentations on data protection. On Wednesday, we had presentations on doing business in each of these three jurisdictions, Russia, Kazakhstan, and Uzbekistan. And this afternoon, we are very pleased to hear from leading members of the three firms from these three jurisdictions on natural resources, investment in natural resources, which is a critical area. And so we're very happy now to start with our friends from the ALRUD firm. And I'll turn it over to Andrey and Boris, and you can manage the presentation for this first segment. Please go ahead.
Hi, Robert. Thank you very much for a short introduction, and I really appreciate the opportunity to speak on this webinar, and thank you for inviting us. Because definitely natural resources, it's one of the main source of, I would say, wealth for the Russian economy. Russian economy in general heavily rely on the natural resources extraction, whether it's hydrocarbons or some minerals, whatever. And definitely investment in this industry is quite important for the whole economy. And definitely we experience for the last, 25, 30 years, kind of different foreign investors who are investing in Russia on different stage. And definitely we expect that some investment still going on. And the topic of our presentation is basically the investment in natural resources in industry in Russia. Before maybe we will proceed, I will shortly introduce myself and my colleague. My name is Andrey Zharskiy. I'm partner in ALRUD law firm. I'm head of our natural resources energy infrastructure practice. I'm already with the firm more than 15 years, and in general having practiced more than 30 years. I would say that I personally had a lot of connection with China, because I think the first time when I visited China was, I just calculated before the actual meeting, was exactly, I think 20 years ago in 2005 or even 2004, when I started to assist in one client buying aluminium and coal assets in Henan province in China, not far from Zhengzhou city. So I was even the member of board of some of the Chinese GV established with some of the local Chinese companies. So, and then I think for the next 3-4 years, I was visiting China almost, I would say, once per quarter, staying for 1-2 weeks. Really appreciate the time. Then I just moved to the law firm. So right now, I think my task is to assist a lot of Asian and particularly Chinese clients in respect to a lot of issues related to natural resources in Russia. And we as ALRUD, I mean, maybe short introduction about ALRUD. It's one of the leading law firm in Russia. We have more than 120 lawyers and with 14 partners. And definitely we work a lot for the Chinese clients in this industry. I mean, just short, for example, I mean, couple of names. It's we assisted China Gold in the acquisition of the majority stake in one of the big gold project in Russia. We before assisted CFC China Energy in respect to acquisition of the minority stake in Rosneft company. So we have vast experience working for Chinese clients. And I would have Boris Pribylov. It's a senior associate from my team who would assist me with speaking on regulatory issues related to the natural resources. Yeah, hi Boris. Boris had...
Yeah, hello everyone.
Yeah, Boris had vast experience assisting Chinese SOE and private company in respect to different issues, due diligence, transaction, regulatory issues related to natural resources. So I think he is currently working on a couple of deals as well. So this is kind of brief introductions. Definitely, I mean, maybe before I pass the floor to the Boris, I would like to mention that currently we have in Russia like a specific regime which distinguishes between foreign investor from friendly states and foreign investments from unfriendly states. Yeah, definitely China is considered as friendly state from point of Russian counter-sanction regulations. So basically, we will not touch in our presentation any regulatory regime applicable to unfriendly countries, because this is right now quite complicated issue. But I hope that all speakers, all participants will enjoy, will learn something new for them, and maybe they will eventually make decision to invest in Russia. So I think, Boris, it's your turn, and I will help you later on.
Thank you, Andrey. Well, let's start. And we would like to start with the general legal framework relevant for the subsoil use in Russia. It should be noted that this framework is common for the majority of types of mineral resources like oil, gas, coal, etc. On the slide, you can see the main laws that regulate this area in Russia. First of all, of course, is the federal law on subsoil, which is a fundamental law in this field and which regulates almost all aspects of receiving the licenses, conducting business activity, etc., etc. The second one is the land code, which generally regulates relations related to receiving the rights to land and use of land for the subsoil purposes. The next one is the federal law on investments to strategic entities and businesses. We will elaborate on the relevant requirements further. And the last one is the federal law on agreements for geological study, exploration, and extraction, which regulates their respective agreements in the field. Apart from the main laws, we would like to highlight the main regulatory bodies which are involved in this sphere. First of all is the Ministry of Natural Resources and Ecology. It is the head body in the sphere, which performs classification of natural resources and observes the industry. The next one is Federal Agency for Mineral Resources, or Russian name Rosnedra, which organizes tenders and auctions for the right to subsoil use, issues licenses, etc. The next one is Federal Environmental, Industrial and Nuclear Supervision Service, or in Russian Rostechnadzor, which oversees compliance with industrial safety and ecological standards in the area of subsoil use. And the last one is Rosprirodnadzor, which supervises compliance with terms of subsoil licenses, monitors the environmental protection requirements, and other ecological issues. Rosnedra, Rostechnadzor, and Rosprirodnadzor perform regular audits of subsoil license holders. So we are facing these names and officials from these bodies quite often. And in case you invest in Russia, you will see them quite often as well. Finishing our review of general information, we would like to highlight that subsoil resources belong to the state, and it is considered to be the state property. To extract natural resources, it is necessary to obtain a license from the state. Therefore, on the next slide, we will elaborate on the content and types of the respective licenses. So, as you can see, there are three types of subsoil licenses in Russia. It is a survey license, production license, and combined license. A survey license is issued for geological survey, including search and evaluation of mineral deposits. So this license does not grant the right to extract minerals itself. Survey license is provided for a limited timing, and which is maximum is 5 years. But it can be extended if needed for completion of survey works. As a general rule, survey licenses are issued without tenders or auctions based on the application of the candidate. To conduct exploration and production of minerals itself, it is necessary to receive a separate license for exploration and production of minerals, so-called production license. This license is received only after the existence of deposits of mineral resources is confirmed under the previous stage. Or there is an alternative option, and it is to have the combined license for both geological survey and exploration of the subsoil in case existence of the deposit is highly probable or already proved. Production licenses and combined licenses can be issued for a term equal to the life of the project. However, in practice, they are usually granted for 20 or 25 years term, but can be extended as well, considering that there are no violations of the licensing terms. It's necessary to note that production or combined licenses can be granted only through a tender or auction, and there are only certain exceptions to this rule. For example, in case of deposits listed by the Russian government and subject to special procedure. To sum it up, if you want to extract minerals, you need to get a survey license plus production license, or you may receive a combined license instead. However, in practice, it's necessary to understand that in practice, the regulatory payments are not limited only to these subsoil licenses, because subsoil use usually presumes presence of different environmental permits, some other licenses, and the set of other general documents. So now I will pass the word to Andrey, who will elaborate on investments.
Okay, yeah, Boris, thank you. Yeah, I think now let's move to the way how foreign investors could invest in natural resources in Russia. Yeah? So definitely, I think this is a key topics of our discussion. And here I would like to point a couple key, let's say, points. First, in 2022, only Russian companies or companies established in Russia are allowed to be license holders. So basically, they're entitled to have or to obtain license in Russia. Before, foreign companies, including acting through the branch, for example, they could also apply and get license in Russia for mineral extraction or for oil production. But right now, it's only Russian companies. Yeah? And this is why when we are talking about investment in natural resources in Russia, yeah, so basically we are talking about corporate deals, yeah, because foreign investors should either establish a subsidiary in Russia, and it could be 100% control or let's say majority control, which later on will apply and get license, which Boris mentioned, or foreign investor should buy stake shares in Russian company, which currently hold license. Yeah? So that is why when we're talking about any investment in Russia, we always should assume that this is kind of corporate M&A deals, and you don't have any like agreement, joint venture, like in some countries where you could have joint venture agreements or maybe production sharing agreements. I mean, we used to have before, but right now the general regime is the way how it is. And as Boris mentioned, so it's irrespective of the minerals, whether it's hydrocarbons, oil, gas, whether it's ferrous metals, non-ferrous metals, whether it's precious metals, gold, diamonds, whatever, you have basically the same regulation applicable to all of these minerals in terms of the way how it could be acquired. And that is why, of course, in most cases, the deals which we are doing for Chinese, for example, investors, that in most cases, acquisition of the minority or controlling stake in Russian companies, which has license for some minerals, whether it's oil or gold or maybe nickel, copper or whatever. Yeah? And basically the way how transactions usually are done. And of course, proper due diligence is quite important exercise, at least at the initial stage, when you're considering to invest in Russia, in order to investigate all risk related to initial acquisition of the license, all risk related to the existing compliance with the license terms. We will later on talk about this. And in terms of possible regulatory regime applicable to the foreign investments, I think on the next slide, I would like briefly to touch this as well. I mean, first, I would like to mention that in general, Russian law doesn't prohibit foreign investor to buy stakes in Russian companies, subject to certain exception for approvals. Yeah? So in general, for example, Chinese company could buy majority stake in Russian company only without any specific approval related to the foreign investment, only subject to some major control clearance approvals. But some restrictions are applicable to the so-called strategic companies in Russia, because we have special law related to the foreign investment in strategic entities. And from point of natural resources, some companies are considered as strategic companies from Russian point of view. And here, this is so-called companies which has subsoil plots of federal importance. Russian law on natural resources specifically mentions the criteria which will trigger basically such company as a strategic company. And as we can see on our slide, any company having license, for example, for uranium, diamonds, nickel, cobalt are considered as strategic. Any company which have oil deposit with amount exceeding, for example, 70 million tons are strategic. Natural gas 50 billion cubic meters strategic. Gold, more than 50 tons of reserves, this is strategic company. Why it's so important? Because if the company is strategic, it means that the special regime will be applicable in related to acquisition of stakes in such company by foreign investor, and specifically by foreign investor which are SOE, state-owned enterprises, or which are controlled by the state-owned enterprises. And definitely, when we talk about the Chinese investment, I mean, in natural resources, in most cases, we deal still with the SOE enterprises, whether it's some oil companies or some mineral, for example, gold company. We work for China Gold, China Silver, for some other as well. And what is a regime is applicable? In order to acquire stakes in such company, you need to get specific approval from the Government Commission for Control over Foreign Investment. And why it's relevant? Because such approval could take, in order to obtain, from 3 up to 6, 9, 12 months. And there is no guarantee that such approval will be obtained. Yeah, so this is complicated, lengthy process, which creates some uncertainty in terms of the closing of the deals, and which definitely affects the regime. And moreover, for understanding, if you're talking about SOE investor, so basically Russian law prohibit acquisition by the foreign SOE of more than 25% of the stake in Russian strategic company, subject to certain exception. So no way, even you cannot apply for the approval. So as you see on the side, the only two exceptions which in practice we see, it's the first when there is a special bilateral agreement signed between the government of Russia and the government of the investor. And for example, in respect to China, we have a couple of such examples. For example, China Gold acquisition of the majority stake in Ключевское gold deposit was approved based on specific bilateral agreement with the government of Russia and China, allowing specifically China Gold to acquire majority stake in such strategic deposit. Some investment in LNG project and, for example, in petrochemical project in Russia also was structured, allowing Chinese companies to obtain more than 25% based on such bilateral agreement. And the second exception is investment in the Russian company which are controlled by the Russian government. And if the Russian government control more than 50% of the assets of the stake in the strategic company, then still the foreign investor, including SOE, could buy up to 50%. So basically, that is why we have couple of joint venture, which are subsidiary, for example, or Rosneft, where Chinese investors or jointly maybe with some Indian investors own more than 25 up to 50% of the stake. But this is allowed. But in general, this is important very issue, strategic investment, because the consequence of non-compliance is the invalidity of transaction. And the possible consequence is that government could actually appropriate assets which were acquired in breach of such regulations. And any indirect even acquisition of assets when structured on the level of some SPV, I know, in Hong Kong, Singapore, would still trigger all these applications. So this is a very sensitive, important issue to be checked while considering any investment in Russia. Okay, let's move, I think, to the next slide, Boris.
Well, let's assume that all approvals for the transaction are successfully received and licenses for the project are successfully granted. So now let's elaborate on the typical license terms and obligations for the holders, which should be observed during the activity itself. We think it reasonable to highlight for our Chinese clients the following licensing terms. Of course, in practice, there are more terms, but these are the key and most important ones. So, first one is the validity period and deadlines in the license, because the license usually provides for certain deadlines for each stage, which should be observed. Then the license provides for extraction limits within certain periods. This could be minimal or maximal limits. The next one is obligations in the field of environment. Environmental protection is really important nowadays and is really observed by Russian state authorities. So they pay great attention to these issues, and we see it in practice really. The next one is possible obligations in social economical development. So license may provide for certain obligations for the investors to provide financing to social sphere, to create workplaces, etc. So and it should be noted that of course a license provides for certain payments, and it is the first payment which need to be made after the license is received. Generally, it is a condition of an auction for granting the license. And then the license provides for regular payments to be made usually once per year. And I think then the last term which we would like to highlight is the obligation related to closure of the project, meaning the conservation of the production site and the remaining obligations. So after extraction is completed, the license holder shall do all things to properly close the deposit. And it should be noted that licenses, of course, can be revoked, and they can be revoked either in case of single violation, but of the major term, the significant terms, or in case a roll of small violations to be made within a certain period of time. Another important issue is granting the rights to the land. It is important to draw your attention that under Russian law, obtaining the subsoil license does not automatically grant rights to use the surface of land plot. The right to use the surface shall be obtained by the subsoil user separately from the subsoil license. In the meantime, of course, the subsoil user has preferential right to receive the land plot without holding any actions, etc. And it's even have a right to demand provision of such land plots from the state. As regards to losing the right to the land, usually it is possible only through a court procedure and only in case of major violations. So generally, in case license is received, a subsoil license is received, the lands are provided and should be held by the license holder. So the state provides such rights. And another important issue, which is commonly asked by our foreign clients, is whether it's possible to acquire or dispose of the subsoil rights separately from the share in the company. The general answer is no. Under Russian law, subsoil right cannot be freely sold or otherwise transferred to another entity, except for certain limited cases provided by law. Also, please note that subsoil rights cannot be subject to the pledge or any encumbrance, etc. In practice, any encumbrance, if necessary, is implemented in respect of the shareholding of the company, which holding the subsoil license. The subsoil law provides for the exceptions for the cases when license can be transferred. You may see them on the slide, but generally all of them relate to intragroup relations or the reorganization of the company. Of course, in practice, it's possible to see different ways to sublicense the subsoil to other entities without formal transfer of the license itself. Of course, for avoidance of doubt, engagement of contractors for certain works and services related to subsoil use is allowed and commonly used in practice. However, such contractors still should be engaged for part of works. Our practice and judicial practice shows that transfer of the whole set of works and rights on the subsoil deposit can be considered as evasion of the subsoil law requirements, meaning that it is the license itself transferred, which is not allowed. And we are moving to the end of our presentation. On the slide, you may see the trends that we highlighted in our practice that we see. Generally, they can be combined into several groups. First is increasing control over compliance with regulatory requirements from Russian state authorities, which includes the subsoil regulations, environmental regulations. So new acts are adopted and the control increases. The next several trends relate to the current geopolitical situation. As Andrey said, there are some jurisdictions which considered unfriendly, but of course it does not relate to China. And geopolitical situation requires change of the structure of the business in Russia. Well, and other trends that you may see. I think I will pass the word to Andrey to
Yeah.
finish.
Yes, thank you, Boris. I think, maybe just a few words to sum up in general the issue. So I think what is important maybe right now is, of course, the issue of the structure of the investment in Russia from Chinese SOE and Chinese investors in general, because we still see, before we used to see a lot of SPVs, specific companies established in Bermuda, in Singapore, and some of the jurisdictions which were used for investment in Russia. Yeah? And these companies are considered as unfriendly for Russian counter-sanction regime right now. So definitely we don't recommend to use them right now because it will create some additional problems, despite the fact that they eventually could be controlled by Chinese investors and being the friendly company from point of Russian regulation. Yeah. So, and moreover, what we see right now, because of all this geopolitical situation, some changes in the equities in Russian companies, we see that some Russian companies are trying to arrange right now joint venture with some Asian investors at the level of the foreign SPVs in which are registered in, for example, in UAE and some of the jurisdiction, which in some cases is not the best way to invest in Russia. So basically, we always recommend to find the way when you will have direct investment in a Russian company, because it will give you more corporate right related to the direct shareholder in Russia. Moreover, you could rely on the benefit on some double taxation agreements between Russia and China, which also will give you some additional protection. So basically, the issue of corporate transaction structure is very important always, and one of the initial stage which you should thoroughly address. Okay, I think it's time to show some of our CVs and questions if you would like to have, or maybe later on, Robert, it's up for you. Thank you very much.
Yeah, let me ask a couple of questions now. First of all, thanks so much for this excellent presentation, very timely and very well organized. Just a couple of general questions. First, Andrey, as I understand it, this presentation focused on the extraction of natural resources. I also noted in your last section on trends that the supply chain, all of the equipment and materials, et cetera, needed for that process are also now being built up. I assume that's also an area for closer cooperation between China and Russia on that part of the machinery, the tooling, et cetera. But also I'm assuming that there are different rules or regulatory elements that would apply to refining and to downstream, et cetera. Do you have any just general brief comments on how those other aspects of natural resources activities would be treated under Russian law?
Mm-hmm. Okay, I think in general, of course, any production activities related to refining or of minerals, it's subject to the regulation applicable. But I think still the key regulatory regime, it's a license to extract and to produce. In some cases, if you're talking about, for example, so minerals, metals, yeah. So production means all process, starting from the extraction, then any kind of washing, production of some semi-products, whatever. So it's covered by the license, and then only subject to, let's say, some regulatory regime related to safety regulations when you need to have, or maybe environmental issue, when you need to have special license, I would say, or approvals. But this is more technical issue, I would say, to deal with, Robert. Usually in practice, once you have the license, it should not be a problem, of course, subject to compliance with the general process related to getting all these approvals. So,
Okay, and Boris, you mentioned about some of the potential risk for revocation of licenses for significant violations. Have you actually seen instances where licenses have been revoked, and in what cases does that usually happen?
Yeah, that's a good question. Of course, there are such cases when licenses are revoked, but Usually it is like the last measure applicable by Russian state authorities, and they usually, even if the violation is serious, they provide time to change the situation. They may impose fines and to send notifications and closely look that the violation is successfully healed. But if not, then they may revoke the license. So that's
All right.
but
Okay,
there are
one
such
last.
cases. Yeah.
All right, thank you. One last question for Andrey. I was, of course, interested to hear that 20 years ago you were regularly coming to China, mostly to the area around Zhengzhou, and so you've had a lot of experience in Russia-China cooperation. I think that it's safe to say that a lot has changed in the last 20 years. And I just wanted to remark that 20 years ago, I was acting for a Chinese SOE doing a major joint venture with a Russian counterparty. And one of the challenges we encountered was that we needed to have all of the documentation in three languages, Russian, Chinese, and English, because English was the only shared language. How are you handling that practical consideration now?
Well, I think right now, I think still, of course, English is a kind of common language which Chinese and Russian counterparties are speaking, and in most cases, all transaction documentation is in English as a kind of key version. Then sometimes you have Russian or Chinese, but I would say I don't see right now three versions of the documentation. If you're talking about some, for example, articleization, of the company, definitely then you have the Russian version as a key, and then you have the English like a second language. But definitely situation improves. So we definitely see more Russians who speak fluently Chinese. And I could say that even in our firm, we have some employees. We see more, of course, Chinese investors who fluently speak English, and don't need a very good translator. But still, I would say the good translator could save the deal right now still. So this is quite important issue from practical point of view.
All right. Well, thanks very much. That was an excellent presentation.
Okay, thank you very much.
Now we invite you to stop sharing your slides. All right. Next, I'm very pleased to introduce Doniyor Usmanov of the Azizov and Partners law firm in Uzbekistan. And he's going to introduce himself, the firm, and also then share his slides for his presentation on natural resource investment in Uzbekistan. Please, Doniyor.
Hello, everyone.
Hello.
My name is Doniyor. I'm an associate at Azizov Partners law firm. So first of all, I would like to thank the organizers of this webinar and inviting me here today. I will be speaking about the regulation of mining activities in Uzbekistan. So Uzbekistan's mining industry is one of the most important and strategic industries. Uzbekistan is the one of the world's largest producer of gold and uranium, as a fact. And in the country, there are two dominant mining state enterprises. One of them is the Al-Malik Mining and Metallurgy Company, which is AGMK, and Navoi Mining and Metallurgy Company, NGMK. So most widely used form of companies in the mining sector are the joint stock companies and limited liability companies. So here's the agenda of our presentation. It includes main laws and regulations in mining sector, regulatory bodies, types and terms of subsoil use, licensing, permit of subsoil use, other regulatory requirements to mining activities, guarantees of the rights of subsoil users, special taxes applicable to mining activities, and finally we will have abandonment, so the process of closure of the mining enterprise at the end of the operations. So let's get started. The first one is the main regulatory acts. So The first act is the law of the Republic of Uzbekistan on subsoil law. This is the main law that governs mining activities and provides protection of subsoil use plots. It should be noted that this law is completely new, as it was adopted last year and came into force this year. In contrast to the previous version of the subsoil use law, the current law provides significantly more provisions on protecting subsoil plots, mineral reserves, and unifies many regulatory acts in the mining sector. So the next one is the law of the Republic of Uzbekistan on environmental protection. This law provides basic environmental regulations that are applicable to mining activities. Then we have a law of the Republic of Uzbekistan on industrial safety. This law establishes the industrial safety standards that mining companies must follow. And we have a law of the Republic of Uzbekistan on licensing, permitting, and notification procedures. This law provides the list of activities that are subject to licensing, permitting, and notification. This law is very important when conducting mining activities because except of the mining permit, there are lots of regulatory permits and license that could be required in the course of conducting mining activities. So finally, we have a resolution of the Cabinet of Ministers, number 133. This is the act that provides specific procedure for obtaining the permit for the mining activities. So here we have types of subsoil use that allowed in Uzbekistan. So the first one is geological exploration that are allowed up to 5 years. The next one is extraction of minerals, which is allowed up to 25 years. Underground storage of mineral resources are also allowed up to 25 years. So then we have artisanal mining, which is small-scale mining done by individuals, and this is allowed for 3 years. So finally, we have collection of samples of collectible materials. This type of subsoil use is allowed for 2 years. So let's focus here. This part is important. So as per Uzbek law, there are certain type of activities, actions for the performance of which it's required to obtain specific document. According to Uzbek legislation, there are 3 types of such document. The first one is the license, permit document, and notification. So as I mentioned above, the list of activities subject to licensing, permitting, and notification is provided by the law on licensing. So under Uzbek law, the use of subsoil is allowed based on the permit document. So permit grants its owner the rights to use subsoil plots within specific boundaries for a specific period of time and establishes the conditions for the use of subsoil plots. So as a rule, a permit is required for each type of subsoil use. In practice, there could be questions. For example, when there is a governmental resolution or presidential decree approving the mining project, does the company still need to apply for the permit? The answer is yes, because the resolution of the government or presidential decree cannot itself grant the mining rights or subsoil use rights to the company. So anyway, it's required to apply for the permit before conducting mining activities at the site. So here we have authorized bodies issuing permits. The first one is the Center for the Use of Subsoil under the Ministry of Mining Industry and Geology of the Republic of Uzbekistan. This body is responsible for issuing permits related to extraction of minerals and geological exploration. The second one is the Ministry of Ecology of the Republic of Uzbekistan, which is responsible for issuing permits related to underground storage of mineral resources. Now let's talk about procedure of obtaining permit. Uzbek law provides 3 methods of granting permits to subsoil users. So they are online auction, tender, and first come, first served concept. The last one means direct negotiations between the applicant and the government. The last one is usually used when there is a governmental resolution or presidential decree that approves and allows the company to conduct certain activities at the mining site. And the method of obtaining permit depends on the type of subsoil use. Here we have requirements to the applicants. The new law on subsoil use sets out the requirements to the applicants wishing to obtain the permit. Specifically, if the applicant is legal entity, it must follow certain conditions. Firstly, it must be officially registered as a legal entity in Uzbekistan. And it should not be in the process of liquidation, and there should not be a court decision ordering the company stop its activities. And finally, the law on subsoil provides requirements regarding the beneficial owner of the applicant. For example, the beneficial owner of the applicant should not have criminal record for fraud or violation of subsoil legislation. Considering above requirements, it should be noted that foreign companies cannot directly apply for the permit because it should have a status of resident legal entity. That's why foreign investors, including Chinese companies, first of all, should establish a resident company in Uzbekistan. In our practice, investors had obtained permits through their subsidiary companies established in Uzbekistan, most of them. As you may have noticed above, the term of the permit for subsoil use is granted for a limited period of time. And there could be a question whether the possibility of extending the term of subsoil use rights. And Uzbek law allows for such extension. So to do this, it's required to submit the application to the Center for the Use of Subsoil in the required form and during the last year before the expiration of the permit. And the application review period is 15 working days. And the authorized state body is entitled to refuse such application on the grounds provided by the law. For example, serious violation of the subsoil legislation or the expiration of the validity period of the permit. In such cases, the Center for the Use of Subsoil may refuse to extend the validity period of the permits. Now let's talk about assignment of the right to use the subsoil. So a permit holder for geological exploration and for extraction may assign its rights under the permit to another person. For this purpose, it's required to obtain approval from the Center for the Use of Subsoil in the form of another permit. And if the new subsoil user agrees to take all obligations under the original permit. In such cases, so the authorized state body can approve the assignment of the right to use subsoil to another person. So the new law on subsoil provides certain guarantees, general guarantees. For example, the right of subsoil user to conduct its activities without interference from state bodies, and such unlawful interference can be compensated by the application of the company to the court. And there is no specific law on the protection of investments in the mining sector. That's why mining investors enjoy general investment protection provided by the law on investment and investment activities of the Republic of Uzbekistan. So this law offers protections such as security of ownership, non-discrimination, and others. Here we have other regulatory requirements that are applicable to mining activities. The first one are the environmental regulations. So the new law on subsoil and the law on nature protection provide certain requirements to mining activities. For example, all mining enterprises, all mining activities are subject to state environmental assessment. So the state environmental assessment is conducted by the state center for the environmental assessment, and such assessment must be done before the conducting main activities at the site. And finally, we have industrial safety regulations. Such regulations are provided by the law on subsoil. Also, we have the law on industrial safety. And according to this law, mining sites are classified as hazardous production facilities. And in the course of conducting works at the site, there could be required another licenses depending on the risk at the site. Here we have special taxes applicable to mining activities. There are three main types. The first one is the land tax. This is paid for the use of land where mining activities take place. It should be noted that when the company is conducting geological exploration, the company is exempted from the payment of such tax. And the next one is subsoil use tax. This is paid depending on the volume of the extracted minerals. For example, the tax rate for the precious metal is 7%, and for example, for the uranium is 9%. And the third type of tax is special rent tax. This is tax applied to the extraction of minerals, and minimum tax rate is 25% of the extracted of minerals. So finally, we have abandonment procedure. This is the process when the mining operations come to an end. So upon the abandonment, the mining company should develop a special technical project and must submit to the Center for the Subsoil Use. And after the approval, according to this project, the mining company is entitled to conduct liquidation procedure of the mining enterprise. And this is the end of our presentation. Thank you for your attention.
All right, thank you so much, Doniyor, for that excellent presentation. I have a couple of questions for you. In the presentation by our friends and colleagues at the ALRUD firm about Russia, they talked about some of the investment structures or investment limitations. Now, you mentioned that in Uzbekistan, it was also necessary to have a legal entity set up in Uzbekistan to be the applicant for the permit and the license. So that part would be similar to Russia. And so that would mean, and I want you to confirm if my understanding is correct, that it would not be possible to have a cross-border contractual arrangement, such as a production sharing agreement or some other type of joint contractual arrangement on a cross-border basis. You must have a legal entity in Uzbekistan to pursue these types of activities. Is that correct?
Yes, we have also the law of the Republic of Uzbekistan on production sharing agreements. And according to this law, if I'm not mistaken, the investor must have a resident legal entity. And in general, in Uzbekistan, foreign companies cannot apply for the license and permit due to technical obstacles, because the license is applied via the electronic system, and such system usually require the applicant to be a local company, for example, to have postal address in Uzbekistan, taxpayer identification number obtained in Uzbekistan. And I mean that even though the legislation of Uzbekistan allows foreign companies directly apply for such licenses, there could be technical obstacles to obtain such license and permits. So anyway, so foreign investors should establish a legal entity in Uzbekistan.
Are there any caps or limitations on the percentage of ownership that the foreign company or the subsidiary of the foreign company can take? Or can foreign companies acquire 100% ownership of these mining or natural resources projects?
Generally, there are no limitations, but because of the governmental resolution or presidential decree, so the parties may establish a joint venture company, and because of the specific of the project, for example, there could be state mining enterprises that could operate with foreign companies and then establish joint venture company. But in general, according to Uzbek law, there are no limitations to the ownership of the mining companies in Uzbekistan.
And as a practical matter, is it more common to see joint ventures as you described, or is it also common for foreign companies to set up an entity and apply for their own license 100% owned by them?
In my practice, I faced both of them. I cannot say that one is more than another.
All right, thank you so much. That was an excellent presentation. We thank you for your contributions. Now we invite you to stop by sharing your screen. Next, we're happy to invite Dianna 10 of the AEQUITAS law firm in Kazakhstan. Originally today, we had hoped to have Yelena Manienko, who's a partner, I believe the founding managing partner of the firm, to join us, but she unavoidably was engaged in something else, and so she's asked a member of her team to make the presentation. So we now invite Dianna 10. If you will share your screen, and if you're able to, turn on your camera so we can see you as you make the presentation. Welcome, Dianna.
Thank you. Hello, everyone.
Hello.
I'm glad to meet you at this event. Well, I will introduce myself. I work at the AEQUITAS about 2 years. Before, I worked at the subsoil use industry and in the mining companies. Basically, in the AEQUITAS, basically I advise on issues related to the subsoil use rights, including gas and oil projects and mineral productions as well. I will tell you a little bit about our law firm.
Hey, Dianna, can
yes.
I ask you to adjust your camera so that, because right now it's cutting you off at your chin. Can you, there you go, perfect. Oh, right there, perfect. Thank you.
Well, AEQUITAS is a law firm established about 30 years ago, and it is one of the reliable firms in Kazakhstan. We are mostly academic, but who is legal agency recognized our firm, one of the best firm of the Kazakhstan, and they recognized us as the legal firm of the year within 2021, 22, 23, etc., until these days. Okay, I will start the presentation and will share the screen.
All right, thank you, Diana. We can see it. We can see it. Can
Okay.
you also put it on full screen so we can see the full slide?
Can you see my full screen?
There it is. Yeah, there it is. Thank you.
Okay. Well, development of the subsoil use sphere is one of the key and most important directions of the Kazakhstan economy. A considerable part of the world's mineral resources is concentrated in Kazakhstan. For example, the country is 12th in the world by oil reserves, 8th by coal reserves, and second by the exploited uranium reserves. In this slide, the extractive industry is the most attractive for investments for both local and foreign investors. Today, the issues of the subsoil use are regulated by the Subsoil Use Code, which was put into effect on 2018. The code cancelled the previous basic law governing the subsoil use issues as applied to all minerals. It was the Kazakhstan Law on Subsoil Use on 2010. And during several years from the date of adopting the code, Kazakhstan has adopted new regulations in furtherance of the code and adopted the previously adopted regulations to the provisions of the subsoil use code. Regulations in the subsoil use area are also governed by the provisions of civil, environmental, corporate, land tax, and environmental and entrepreneurial code. Other sectoral legislation, of course. And the most important international treaty relating to subsoil use and ratified by Kazakhstan is the Energy Charter Treaty, adopted in 1994 in Lisbon. International regulation also covers environmental protection, legal statute of the Caspian Sea, and other issues. Caspian Sea is the most important area of the regulation in Kazakhstan when we talk about the gas and oil and gas projects. Kazakhstan subsoil use right is granted in order to conduct the following operations: geological study of subsoil use, solid minerals exploration, solid minerals extraction, common minerals production, use of subsoil space, and prospecting. Subsoil use right represents an opportunity provided by the code to use subsoil within a defined land plot under the terms on a fee-paid basis in the allocated plot for business purposes. And subsoil use right may be granted to local and foreign legal entities and also individuals. It also may be granted to several persons under the same contract. Such persons are joint right holders and may hold the subsole use right only after determining the share held by each of them. Subsole use right may be acquired in the event of I'm sorry. I must say that subsole use right originates on the basis of a license or a subsole use contract. There are two regimes in Kazakhstan. You may obtain the license or conclude a contract. In the event of granting the subsole use right acquired or I would say granted by public authority. It is the Ministry of the Energy or the Ministry of the Construction. Two public authorities may grant the subsole use right. Licenses are issued for certain types of subsole use operations, and the contract may be concluded only for the purpose of exploration and production of oil and uranium, oil and gas and uranium. It is essential that individuals and legal entities who are not national companies may be granted subsole use right under a contract according to the auction results. Subsole use right is granted to national companies on the basis of direct negotiations. The maximum duration of gas and oil exploration cannot exceed 6 consecutive years, and if the case is about an offshore subsole block or complicated gas and oil projects exploration, the exploration duration cannot exceed 9 years. In order to evaluate the discovered deposit, including trial production, the term for exploration under the gas and oil exploration and production contract may be one time extended with respect to each discovered deposit. For the term up to 3 years, and if the case about an offshore subsole block or complicated blocks, the period may be not longer than 6 years. The maximum duration of the production cannot exceed 25 years, and at major, the unique fields, 45 years. The period of production may be extended to the term not longer than 25 years. Legislation regulates not only the transfer of subsole use right, but also the subsole use right-related objects, which include participation interests, shareholdings in a subsole user legal entity, and in a legal entity that has the possibility to directly or indirectly define such subsole use rights decisions if the legal entity's principal activities are associated with subsole use in Kazakhstan. transfer of subsidial use rights, same as the transfer of the subsidial use right related objects, except for certain specific cases established by the subsidial use code, and it is allowed only on consent of the competent authority, those two ministries, as I said before, which are issued, which issue for each individual case for such transfer. I mean that the transaction consummated without the competent authority's consent is deemed null and void. The subsidial use right is transferred by way of reissuing subsidial use license or introducing amendments into the subsidial use contract accordingly. Of regulation previously in effect remain in force until expiration of such contracts or introduction of relevant amendments, that is, provisions on in-country value, confidentiality of information, including geological information, amount and reimbursement of historical costs, penalty for failure to perform obligations, and etc. What are the main payments for the subsidial use companies? The main payments are, you may see at the screen, it is signature bonus, this one-time payment, which should be paid after the company is granted the subsidial use right. Payment to discover historical costs. As a rule, this payment is also one-time payment. Alternative subsidial use tax, royalties, a share of Kazakhstan within production sharing agreement. I must say that such a SPA, share production agreement, is valid, but they do not included as a practice currently, and they were excluded from the subsidial use code. The mineral extraction tax. This tax is payable in case of opening the deposit when the subsidial use company made the research after the exploration of the field, and if there are any production and mineral deposit, they should pay this mineral extraction tax and excess profit tax. How does the subsidial use right terminate? Among the grounds stipulated by legislation for termination of the license or subsidial use contract, we may distinguish the following basis for termination of the subsidial use right. The first one, of course, expiration of term for which a license has been issued, subsidial use contract has been entered to. Liquidation of the legal entity, which is the subsidial user, revocation of the license or its invalidation. It may be revocated if the company did not fulfill its obligations under the license or the contract. or its termination of a contract, or its subsoil uses contract cancellation by agreement of the parties, and adoption of the resolution by the government of Kazakhstan on prohibition or to use the subsoil use log in accordance with the code. Moreover, the competent authority may early terminate the subsoil use contract if the subsoil use company does not comply with the requirements for obtaining the permission when this contract was when this contract or the shares were acquired without the permission of the competent authority. On final note, it is worth to say that subsoil use sphere is one of the most complicated vectors of public relations in Kazakhstan. The most of practical issues relates to the most of the issues relates to the practical and the and requires the analyzing and investigating in each individual case. This is all for today. Thank you. Sorry, Robert, we can't hear you.
Okay, thank you so much, Dianna, for stepping in to help out with this presentation. Again, I'm very happy that we can introduce your firm once again to our friends across China. And we noted in previous sessions that it had been highlighted that AEQUITAS had been Firm of the Year in several consecutive years, and we're very happy to have you participate. I just had one last question, and that is, you had indicated, if I understood you correctly, that a foreign company could also apply for a license. But is that common, or is it more common, as in the case of Uzbekistan and Russia, that you set up a formal legal entity in Kazakhstan and then apply for the license?
I would say that yes, we are familiar with the practice when the foreign companies were granted for these licenses or contracts, and the main practical issue that it became more complicated when you are subsoil user in Kazakhstan and you are a foreigner. There are many questions arise related to the, as I said, practical cases, and it is, of course, it is much more simpler when the subsoil use company is the local company in Kazakhstan.
When foreign investors come into Kazakhstan, is it common for them to set up a 100% wholly owned subsidiary, or is it more common for them to have a joint venture or joint investment with a Kazakh company?
50-50. It is. I would say that it is common when the investor entered to the Kazakhstan by acquiring the shares of the shares of the shareholder or participation.
So in Kazakhstan, would it be common to have project companies that are focused on doing exploration and initial development of the mineral resources, and then they are looking for a bigger investor to come in and take shares in their company so that they can fully exploit the opportunity? Or is it more typical that a foreign investor is buying shares in a very large existing Kazakh company?
Oh, well, Robert, I would say that the first option is more commonly in Kazakhstan. When investor came to the Kazakhstan and buy the project when the exploration is actually completed.
All right. Thank you very much. Thanks to all of our panelists and participants. We appreciate your making time to share your knowledge and experience with our audience here in China. And we look forward to having many opportunities to cooperate with you. So thanks again. And we'll see everyone next time.
Thank you.
Yes, thank you very
Bye-bye.
much, Robert.
Thank you.
Thank you. Bye.